Hi everyone, welcome to Legal Talks by Desi Kanoon. I am Suyash and today I will talk about Section 13B of the Hindu Marriage Act that deals with divorce by mutual consent. Section 13B provides that a petition for dissolution of marriage may be presented to the district court by both the parties to a marriage on the ground that they have been living separately for a period of 1 year or more, that they have not been able to live together, and they have mutually agreed that the marriage should be dissolved. It further provides that when such a petition is presented before the court, then 6 months after the same, and not later than 18 months, if the petition is not withdrawn and a second motion is made seeking divorce, the court may make an enquiry and pass a decree of divorce. Thus, we see that Section 13B of the Hindu Marriage Act provides for divorce by mutual consent. In order to understand the same in a better manner, let us go through the pertinent observations made in various judgments by the Supreme Court. Firstly, in the case of Hitesh Bhatnagar versus Deepa Bhatnagar, the court explained that following conditions need to be met before passing of a decree of divorce under Section 13B of the Hindu Marriage Act. A second motion of both the parties is made not before 6 months from the date of filing of the petition and not later than 18 months. B. After hearing the parties and making such inquiry as it thinks fit, the court is satisfied that the averments in the petition are true. And C. The petition is not withdrawn by either party at any time before passing the decree. Secondly, in the case of Inderjeet Singh Rewal versus State of Punjab, it was held that conjugal rights are not merely creature of statute but inherent in the very institution of marriage. Hence, the approach of a court of law in matrimonial matters should be much more constructive, affirmative, and productive rather than abstract, theoretical, and doctrinaire. It was further held that interregnum waiting period of 6 months is intended to give time and opportunity to the parties to reflect on their move and seek advice from relations and friends. In this transitional period, one of the parties may have a second thought and change the mind not to proceed with the petition. Thus, withdrawal of consent can be unilateral prior to the second motion. Thirdly, in the case of Aparna Mehta Kapoor versus State of UP, it was observed that the Supreme Court may dispense with the statutory limitation period of 6 months, provided that the application under Section 13B seems bona fide and there is no impediment in accepting the same to put an end to acrimonious disputes between the parties. Fourthly, in the case of Priyanka Khanna versus Amit Khanna and another, it was noted that when it becomes apparent to the court that the relationship between the couple has broken down in a very nasty manner and there is absolutely no possibility of a rapprochement between them, even if the matter was to be adjourned for a period of 6 months as stipulated under Section 13B, then application under Section 13B of the Hindu Marriage Act should be allowed to dissolve the marriage between the parties. And lastly, in the case of Hitesh Bhatnagar versus Deepa Bhatnagar, it was also held that the most important requirement for a grant of a divorce by mutual consent is free consent of both the parties. In other words, unless there is a complete agreement between husband and wife for the dissolution of the marriage, and unless the court is completely satisfied, it cannot grant a decree for divorce by mutual consent. Therefore, I hope that the mandate of Section 13B of the Hindu Marriage Act is clear by now. So, what are my concluding remarks? In conclusion, following important points emerge with respect to Section 13B and divorce by mutual consent. A joint application under Section 13B must be made by both the parties before the court. B. A second motion of both the parties is to be made not before 6 months from the date of filing of the petition and not later than 18 months. C. The court must be satisfied that there is free consent of the parties in moving of such an application. D. The petition is not withdrawn by either party at any time before passing the decree. And E. Limitation period of 6 months could be waived provided that the application under Section 13B seems bona fide and there is no impediment in accepting the same to put an end to acrimonious disputes between the parties. Hence, I hope you enjoyed listening to the show. Thank you for listening. Please do not forget to like and subscribe us. And if you have any comments, please make them in the comments section. See you next time. Till then, stay tuned.